One of the most important parts of the Civil Rights Act of 1964 is Title VII, which prohibits racial and gender discrimination in employment. Other civil rights laws, such as the Americans with Disabilities Act and the Age Discrimination in Employment Act, make other forms of employment discrimination illegal. However, regardless of the type of discrimination involved, all employment discrimination cases involve certain predictable legal elements. Any plaintiff who files an employment discrimination lawsuit has the initial burden of proving four different things. First, they must demonstrate that they are a member of a legally protected class. For example, individuals bringing a disability discrimination lawsuit must demonstrate that they are disabled. Individuals bringing an age discrimination lawsuit must prove that they are at least 40 years old. This is usually very easy to prove because it is almost always obvious. Second, plaintiffs must demonstrate that they experienced an adverse employment action. This can encompass virtually anything negative that happened to them on the job. It can include being fired or demoted, or failing to receive a promotion. It can include being transferred or given new responsibilities. It can include changes in vacation time or other benefits. It can include not being hired at all. Once again, this is usually a very easy element to prove, because if the employee hadn't suffered any adverse employment action, they wouldn't be filing the lawsuit in the first place. Third, the employee must demonstrate that they were actually performing their jobs competently, or that they were qualified for a job they did not receive. Employees try to prove that they were good workers, but this element is much harder to prove than the first two elements, because the employer tries to demonstrate that they were bad workers. This often makes civil rights trials very bitter and nasty affairs. Fourth, the employee must demonstrate that action was taken against them selectively, and that other, similarly situated employees did not have any negative actions taken against them. For example, if a white employee and a non-white employee both stole money on the job, and only the non-white employee was fired, it would be easy to prove this element. If the employee cannot provide evidence for all four of these elements, then the case must be dismissed. But if the employee does provide evidence of all four things, then the burden shifts to the company. The company must then justify its action by demonstrating that it had a legitimate, non-discriminatory reason for it. The employee has the chance to challenge the truth of the employer's justification. To see how this works, let's consider a racial discrimination lawsuit filed by some Disneyland employees. Disneyland operates a van pool service to shuttle employees from its resorts to their cars and homes. In order to participate in that program, employees had to sign an agreement that they would refrain from consuming alcohol in the vans. Arnaldo Pinto and his friends were Latinos working as landscapers. In addition to taking advantage of the van pool program, they also enjoyed having a drink or two after work. Unfortunately for them, one of their fellow Disneyland employees and riders, a Caucasian passenger, reported that they were drinking in the van. An investigation found Pinto and his friends had indeed been drinking. But it found that the Caucasian passenger who had reported them had also been drinking. Pinto and his friends were fired, but the Caucasian passenger was not. Pinto filed a lawsuit. First, he had to prove that he was a member of a protected class. It was easy to prove that he was a Latino. Second, he had to prove that he had suffered an adverse employment action. He had been fired, an act that was easy to prove. Third, he had to prove that he was a good worker. Although in many employment discrimination cases, the employer tries to show they were a terrible employee, that didn't happen in this particular case. Disneyland admitted that Pinto was a good landscaper and performed his job well. Finally, Pinto had to demonstrate that action was taken against him, but not against other employees who were similarly situated. In this case, Pinto argued that he and the other Latino employees were fired while the Caucasian employee was not fired, even though they had all violated the rules by drinking alcohol in the van. So Pinto provided evidence for all four elements. So the burden now shifted to Disneyland, requiring them to demonstrate that it had a legitimate, non-discriminatory reason for firing him. It was able to do so successfully, because it is acceptable to fire someone for violating company policies. But Pinto argued that Disneyland was just making excuses for racist behavior. He argued that if Disneyland had really been concerned about drinking on the van, it would have also fired the Caucasian employee who had been drinking. However, Disneyland argued that the Caucasian employee was not similarly situated to Pinto, because the Caucasian employee had reported the misbehavior to the company, whereas Pinto had not. Disneyland said that it did not want to discourage employees from reporting violations in the future, and therefore, it was rational not to fire the employee who had done so. Ultimately, the court agreed with Disneyland, and Pinto lost his case. In a later video, you will watch highlights from an employment discrimination case involving disability discrimination. As you do so, make sure to watch out for the various elements discussed in this video.